Let me now discuss Rules 27 and 28. Rule 27 is your motion for the production or inspection of documents or things. And how do you avail of a motion for production or inspection of documents or things? You can avail of this mode of discovery by filing a motion indicating good cause, and the subject of the motion is to require a party to produce or permit the inspection, copying, taking of photos by or on behalf of a party of any designated documents, papers, books, accounts, letters, photographs, objects, or tangible things that are not privileged, which constitute or contain evidence that is material to any matter involved in the action that is in his possession and control. It will also cover permitting a party entry upon a designated land or other property in his possession or control for purposes of inspection, measuring, surveying, or taking photographs of the property, or any designated relevant object or operation that is ongoing within the property. The object of this mode of discovery is to determine contents or the status of documents or things, or for purposes of the preservation of these documents or things. In the discussion outline, I cited the case of Solid Bank Corporation versus Gateway Electronics Corporation, indicating the requisites that have to be complied with for purposes of compelling the other party to produce or allow the inspection of documents or things. So we already mentioned it earlier. First, there must be good cause. Second, there must be notice of the filing of the motion, which must be served upon all the parties. There must be a designation of the papers or things that are to be produced or inspected. The papers or things should not be privileged. Fifth, that they constitute or contain evidence that is material to any matter involved in the litigation, and they are in possession, control, or custody of the other party. If these requisites are met, then you can have a motion for production or inspection of documents or things favorably acted upon by the court. Rule 28, on the other hand, involves a physical or mental examination of a person. This mode of discovery can only be availed of if the physical or mental condition of the person to be examined is in controversy. Meaning, it is the physical or mental condition of the person that is being litigated or is the subject of the action. Like, for example, in an action for guardianship, where there is a claim that the petition is being filed because of the inability or the physical or mental inability of the ward to manage his or her own properties. So in this case, it is the physical or mental condition of a party that is in controversy. A Rule 28 examination of person would be applicable. Another illustration is when you are moving for a dissolution of the partnership on the ground of insanity of a partner. So the mental condition now of a partner is in controversy in that action for dissolution. So you can avail of a Rule 28 mental examination of that partner who is alleged to be insane. Procedurally, Rule 28 provides that it can only be ordered upon motion for good cause shown, with notice to the party to be examined and to all other parties, specifying the time, place, manner, condition, and scope of the examination, and who is to undertake the examination. One thing that you must be aware of is that once the examination is completed, the party who was examined may request a copy of a detailed written report of the examining physician setting forth his findings and conclusions. As a consequence of this request and its eventual granting, what will happen now is there will be a waiver of privilege, because subsequently thereafter, the party who caused the examination of a person who had requested now for a copy of the results of his examination would now be entitled to request him a like report of any examination that was previously or will thereafter be made. So specifically, if the issue is the mental condition of A, it is now sought, or the mental examination of A is sought by B. So, if the court grants the sought after mental examination of A, and A will subsequently request a copy of the results of his mental examination, B now would be entitled to request of A copies of results of the same or similar mental examination of his person previously undertaken or subsequently undertaken. So if there was a previous mental examination, B can request a copy of the results of that previous mental examination. So if, for example, also, if the mental examination of A indicated that he is insane and A requested a copy, and after requesting a copy of the results, he causes another mental examination of himself to be made to confirm the findings, B would be entitled likewise to a copy of the results of the findings of that mental examination subsequently made. Furthermore, if a party examined refuses the request, meaning the request to show or to furnish copies of results of examinations previously or thereafter made, the court on motion may order delivery by the party examined on such terms as are just, and if the physician fails or refuses to make a report, his testimony may be excluded if his testimony is subsequently offered at trial. So that is the waiver of privilege that actually arises when the party examined would subsequently request for a copy of the results of his mental or physical examination. So that is Rule